Hello, this is Dr. John Olson, barrister, law lecturer and expert witness, and this is Radio Law. Today I'm going to talk about the importance of circumstantial evidence. Now, a lot of people seem to think that circumstantial evidence is less valuable than direct evidence, such as DNA, blood and fiber samples, and eyewitness testimony. It is not. Circumstantial evidence plays an important part in almost every criminal case and in many civil cases. The point about any evidence is to make it as persuasive as possible. This is the advocacy task of the lawyer presenting it. Is the evidence such that the jury is able to draw a conclusion from it which will be adverse to the interests of the defendant? Now, a jury can conclude facts from evidence, whether that is direct evidence or indirect evidence. Circumstantial evidence is a species of indirect evidence, and lawyers talk about a jury drawing an inference from evidence. If you as a lawyer can persuade a jury to draw an adverse inference from evidence, then you can obtain a conviction. Equally, if you as a defense lawyer can persuade a jury that certain circumstantial evidence does not lead inevitably to a conclusion, you can sow doubt in the jury's mind. So as a result, we should never underestimate the importance of circumstantial evidence. The classic case of circumstantial evidence is the US government's case against Al Capone in 1931. You will recall that Al Capone was the most famous gangster in the world in the 1920s and 30s. He was so famous that his name needs no introduction. His picture was on the cover of Time magazine as Man of the Year in 1913. Al Capone is still famous today. He's the byword for organized crime on a truly massive scale. Hollywood is still making movies about this man who at one time earned more than $100 million in a year. The dark side of his character, though, is that he was in reality a ruthless, murderous, opportunistic gangster. For years he blotted the Chicago landscape with an organization that was more powerful than any police department. For years he was the thorn in the side of the establishment. But organized crime people are loyal, and almost nobody would ever have dreamed of betraying Capone to the authorities. So at the beginning of 1931, the authorities knew that it would be next to impossible to prove Capone's involvement or participation in all those endless murders, and that included the St. Valentine's Day massacre of 1929, and in the transportation of alcohol bootlegged across state lines, in prostitution and in gambling. So they changed their approach and decided to get him for something much more mundane, namely tax evasion. The authorities knew that they could not directly show that Capone had an income. Al Capone was very clever at hiding his assets. Nothing was in his own name, not his properties where he resided or his many clubs, speakeasies or houses of prostitution, nothing. So although they would not be able to prove that he had an income, they were going to try to prove that he spent money. Inference can easily be drawn. If you are spending money, you must be earning money. And if you are earning money, you must pay tax. And if you have not paid tax, then you are evading tax and you are breaking the law. So they were going to try to get him on having broken the tax laws. The government called a number of witnesses to prove their case, using only circumstantial evidence. One witness was Chester Bragg. He had taken part in a raid on one of Al Capone's premises, a large club in downtown Chicago. There was no paperwork to show that this club belonged to Capone, or that he even owned one table or chair in it. Under examination, Chester Bragg said, quote, "My job was to watch the front door and keep anybody from going in or out. A big, powerful man tried to get in and finally forced the door open. I got sore and asked him, 'What the hell do you think this is, a party?' And he said, 'Well, it ought to be a party. I am the owner of this place.' And that person was Al Capone. And the inference was that if he claimed to own the place, then he must have spent money on it, which means that it must have been generating an income. But of course, he had paid no taxes. That was sufficient for this witness, and that is the power of circumstantial evidence. And from this witness, the jury was able to draw an adverse inference to Al Capone's case. Another witness was Leslie Shumway, cashier at one of Al Capone's gambling houses. He was asked in oral evidence at Capone's trial if he had ever seen Capone make any bets in that establishment on horses. "No, sir," he replied. Prosecutor then asked, "Do you know whether he made any bets there?" And Shumway replied, "Well, he has made some over the wire, but he didn't make any in the establishment." The lawyer then asked him, "Did you ever see Al Capone's name on the wire record as having made bets over the wire?" And he replied, "Yes, sir." And this too was evidence from which the jury could draw an adverse inference. So we need to forget that some people call it, quote, "just circumstantial evidence," unquote. It was a lot more than that. It showed that Al Capone was spending money making bets. If that was the case, then the money must have come from somewhere. Al Capone must have earnings, which, however, he had not declared. On another occasion, it was obvious that the defendant had large amounts of money. Henry Hoover carried out a raid on one of the premises associated with Capone. He gave evidence that he'd followed Al Capone into a back room at the establishment, and under oath he stated that when I saw him there, he was taking the money out of the till and putting it into his pockets. Note, pockets plural, which suggests several amounts of money. And the fact that he was taking it out of a cash till in the establishment must have meant that he had control of of the till, and likely control of the whole establishment. And from this, the jury were able to draw the inference that Capone was possessed of a large amount of money upon which he had paid no taxes at all. Another witness was Morrissey Smith, who was a clerk at the Metropole Hotel in Chicago, and he showed the court hotel records totaling thousands of dollars for parties, rooms, and what he termed incidentals, all paid for in cash by Al Capone, who had registered at the hotel under a false name. When this testimony was objected to by the defense attorney, the trial judge quickly cut in with this comment: if there's money going out, then there's a presumption that it is coming in. So here too the jury was able to draw an inference, helpfully guided by the judge. If he is spending money, then he must be earning money, and if he is earning money, why has he not paid his taxes? There was also evidence of Capone's lavish dress style, which included silk socks, ties, and suits, some of which cost more than $500 at the time, a fortune in today's money. Apparently, Al Capone bought silk underwear for $12 an item, which was more than most people earned in a week in those days. Thus, Capone was able to be presented as someone who lived a lavish lifestyle, something which would have presented him as completely unsympathetic to a jury of hard-working people living in the era of the Depression, when millions were unemployed and hundreds of thousands were homeless. So for all these reasons, the jury were able to conclude beyond reasonable doubt that Al Capone had a substantial income, and therefore he must be guilty of tax evasion because he had paid no taxes. And that is the power of circumstantial evidence. There was no direct evidence in the case, only the evidence that could be inferred from Capone's conduct. Here we see that a prosecutor can build a very powerful case based only on circumstantial evidence. Remember, the goal of circumstantial evidence is to present it in such a way that it would be hard for the jury not to draw adverse inferences about the defendant. And here is a final point about circumstantial evidence. Unlike scientific evidence, it cannot easily be refuted. You can easily argue that a DNA sample was contaminated, or that proper procedures for the handling of certain physical samples were not correctly followed. But if circumstantial evidence is presented well, as it was in the case of US v. Al Capone, it is almost impossible to refute. Thank you for listening, and goodbye until next time.